I just wanted to introduce our two speakers today. We have Judge Debbie Branham and Attorney Michael Wright with us. And Judge Branham has been a lifelong resident of Kershaw County. She graduated from Camden High School. Go Dogs. She has been our probate judge since 2014, so she's been doing it for a while. She knows what is going on. We work with her in our office when we are dealing with the states that are in probate. So we appreciate that she is joining us today. She, before COVID, would actually do some of these kind of seminars on her own to help people. It's an intimidating process. And so we're glad that we have this platform for her to share her expertise with us today. So thank you for that.
For having me.
We also have Michael Wright. He's an attorney with Savage Royal and Shaheen. He's been there since 2012. He has been a partner since 2015, and I can't list all the things that he has done, but I can say he's worked with individuals, businesses, disputes, mergers, acquisitions, the whole gamut of things. But I also know that on a personal note that he really has a heart for helping people with this kind of thing, with helping them get their estates in order. And on a very personal note, he helped a mutual friend of ours a couple of years ago who had, her husband had a catastrophic medical emergency. And I know that he and Jeffrey helped her with some financial concerns that she had, how bills were going to get paid, what the insurance was and what it was going to cover, so she could focus on the important thing, which was her husband's health. And so not only do you have two very knowledgeable speakers today, but you also have two people who really have a heart for helping others in these situations. And so thank you so much for joining us, and I will pass the floor over to them.
Okay, Michael, you start off.
I like to defer to the judge generally, but okay.
Well, I'll hand it over to you. That's fine.
Thank you, Your Honor. Shelley, thank you very much. One, for organizing this, but two, for the very, very kind introduction. We really appreciate that. I think, the judge would agree with me that if you get into public service, you do this kind of work, you are invested in this, and you want to make sure that that folks are cared for the best that you possibly can. And that's what a lot of this process is. Really what Shelley touched on, I think, is the genesis of this seminar. There was, I've been practicing for a while, but I think this particular incident brought everything to a head. Really tough situation. A husband had a catastrophic injury, and his wife, just quite candidly, did not know anything at all about the financial affairs of the household. She was responsible for raising two beautiful kids, and that was just not something that she focused on. And it was like putting a puzzle together, a very difficult puzzle. We rooted through his office, and we put together bank statements, and we put together some different bills, and we were finally able to get her to a place where she needed to be. He has since recovered. They're on a good track. But it was a really stressful time for her, and it was something that she did not want to have to deal with, nor should she have had to deal with. But that really kind of brings us, I think, to this estate planning process, because when folks think about estate planning, they think about a will. But I think an approach to this should be much more of a holistic one. It needs to be focused on not only what you're going to do with your will, but there's something that's called a durable general power of attorney. Thankfully, this couple had one in place. And just in very short terms, what a durable general power of attorney allows you to do is to act as that other person if they are unable to do so. So you can go in and open up a bank account. You can sell a piece of property. In that particular situation, it was incredibly helpful because it allowed her to speak to investment firms where this individual had 401k accounts and had Roth IRA set up. Otherwise, she wouldn't have been able to do that. And so you think about wills, you think about a durable general power of attorney. One of the other things that's really important, and some of the information I sent out in advance was on a healthcare power of attorney. And that allows an individual to talk to the doctors, that does not violate any sort of HIPAA privilege. It allows an individual to choose an agent and then let that individual speak to the doctors about whether or not the individual's an organ donor, whether they want any life-sustaining treatment, feeding tube, end of life type scenarios that can be addressed in a document that if it's not talked about now, then it's governed by emotion at that particular point in time. And frankly, maybe a decision that the parties had not discussed before and that folks may not be aware of. So, what I'm hoping, and I want to turn it over to the judge for a couple of reasons. One, she's more knowledgeable about this than I am, and two, she's the judge. But what I'm hoping comes from this is that we start to kind of talk about these issues. And as we highlight some of it, I think questions will start to flow. And I found that in these situations, having just an open dialogue and discourse about some of the issues that may be present in your lives or posed as a hypothetical are really important, because that back and forth allows us to fully answer, a particular question that you might have. So as we go through this, I really encourage you to stop us at any point, ask any questions that you have, something that you may not understand, something in the documents that were sent out to you in advance, so that you guys can get a better understanding of some of these really important decisions that need to be made now as opposed to down the road. And the last thing, I'll turn it over, and I generally mean this. I tell clients this all the time, that if you don't take care of this estate planning, I think it's incredibly selfish. And the reason I say that is because you are handing your problems off to your loved ones who may not know at all about what your desires are. And while it's a difficult topic and no one wants to talk about it, and it's something that takes years in the making to finally do, I mentioned before, most of y'all got on, and sometimes I'll have a client come and talk to me, and then I won't hear from them again until 6 months, 12 months down the road when some life event happens and they realize they need to do it. But my point in saying all this is if you don't take care of these issues, then you're likely putting your family in a bad position down the road. Judge?
Yeah. Well, you did a great job explaining things, Michael, and to piggyback on that, the estate planning process is so much more than a will. The probate court handles conservatorships and guardianships. And in essence, the reason we have to get involved is no one had a durable power of attorney, or no one had a healthcare power of attorney. So the durable power of attorney that's in place and will keep you from having to come to the probate court to ask that someone be appointed to take care of a loved one's affairs while they're alive, but incapacitated to the point where they can't do it. It's a emotional process because you're going through some kind of tragic event at the moment. It's an expensive process. You're going to have to get an attorney to help you because it's so complicated. It would be so much easier to get that durable power of attorney. To me, that's more important. That's probably the most important part of an estate plan because it affects you while you're alive. It affects your home life, your family. If you don't have a will, the state of South Carolina says, where your property goes and how it's devised, but there's nothing to say who I want to be in control of my finances if I've had a stroke and I'm unable to take care of my business. So, that power of attorney, but I think what I see is, and I saw it in the law firm before coming to the probate court, folks don't like to talk about it because I used to have clients that say, well, I know I need to do a will, but that means I'm going to die, that kind of thing. And so, Michael, yeah, you're exactly right when you said it's just the selfish or it's just an unfair to your family, to your loved ones, to yourself if you don't take the initiative and talk to your spouse or your loved ones, if your adult children, about your estate plan and get one in writing And please, they have these forms online, but that I request, beg of you to go to an attorney that in the area that has experience in probate matters, that knows how to listen to your whole um, estate situation, what's going on in your life, and what you want to happen to your property, or what you want the future of your how you want your family to go on after you, and be able to explain all the ins and outs of what's going on that's really specific to your household, and they, through all that information, be able to advise you what the best route to go. That attorney, that estate planning attorney, will probably talk to your accountant, because a lot of folks really don't know what all's involved, as far as, yes, we've got a couple accounts, but there are tax consequences, that could happen. So that attorney's going to talk to your accountant and say, okay, what's going on? Because a lot of folks just let the accountant file their taxes, they pay the government, and they're done with it. And there's, that thing. But they're, working together, they can probably maybe save you some heartache and some money, just knowing what's going on financially with your situation. But talk to your spouse, talk to your adult children, and let them know. Get that plan in place. Talk to an attorney, and talk and get something in writing, so that if something happens and you're in an accident or whatever it is, that you become incapacitated, you have that durable power of attorney in place. And if something happens and you leave this world, that you've got a document saying, I want Sally to be the personal representative of my estate, and this is who I want to have my assets. So in that estate planning, and that Michael, I'm sure, talks to everyone about, whenever, you want to avoid things coming through probate. I've got plenty of work. You don't really have to come through probate, with a good estate plan. But sometimes you do want things to go through the estate, because there's tax issues involved. So some things need to go through the estate, and some things don't. So that's all in what is involved. That information is involved in doing your estate plan. It's depending on what kind of estate you have. Some have a nice size estate. Some people just own a car, some savings accounts, a few little IRAs or something, that's not, crazy, involved with different, with the accounting and stuff. So the less that you have on a general basis, the less that has to go through probate is better. And Michael we can talk about that, what things can come in place to avoid the probate process. So when I have my workshops quarterly, the goal of my workshops is to not scare the folks to death, but give them a great picture of the whole process. And after that is done, they go home and think about what have I talked to my spouse about? Does my spouse, if I was to drop dead today, would my spouse be able to know where the checkbook is? Would they know when the bills are due? Those things are important to talk about. And I see Miss Brown, Catherine. Yeah, I'm the same way. In my household, I take care of, Donald has a store to deal with. I take care of the household bills, but I have everything, just because of who I am, in a folder with instructions. This is the password to this online banking or whatever, or the light bills drafted, have that in place, make you just an instruction sheet. Please let your spouse know where the passwords are to your different online accounting or online banking or online everything, even down to the Facebook. You would not believe how much litigation we have in probate court over a Facebook password. So those are things that a good estate plan will will talk about and plan for. But communication, oh my gosh, that's my big thing. I need a big billboard that says communication will solve a lot of your issues or a lot of your problems. Just talk it out. It's a hard conversation, to have, especially like in your younger years, like, oh, I'm not going to die, or I'm not going to have a stroke, or I'm not going to be in a car accident. What are the chances of that ever happening? But it could happen. And when it happens, it's devastating. So talk to your spouse. If you don't have a spouse, talk to um, your children or whoever that you feel is going to be the person that you would put in charge. And so when in the workshops, when I talk about putting someone in charge, I, and I saw it in the law firm, I'd have a little lady come in and I'm going to will everything to John, because he's the oldest and he will share with those children. John's gonna get amnesia after mama dies. And so, spell it out. Spell it out. Yeah, John can get his share, but if you want Sally and Jane to get their shares, you better put it in writing specifically. And I talk about life insurance. And it happens so often. I know Michael has seen it too. One child, the oldest, it's always the oldest for some of these generations, the older generation, I guess. It's just the way it is. But the life insurance is made payable to one child. And they're going to pay for my funeral, and then they're going to share it with the other children. Well, okay, they may pay for your funeral, and then they may not. And they may share, but then amnesia may come in, and once they find out that's their money legally because they're the beneficiary, sometimes, especially if there's a little tip there, they won't share. So on your life insurance, name all three. They all got to sign to bury you, and then they can look at each other in the eye and say, so you're not going to bury mama, or you're not going to take care of mama's funeral expenses, and then they get to share whatever's left. So those are the things. In deciding who's going to administer your estate as far as being appointed the personal representative, if your child has come to you your adult child has come to you in the last year to borrow money, don't name them the personal representative, because they're in charge of making sure your estate is administered correctly, that the creditors are protected, and that the other children have their things are managed correctly so that they get their share. So it's okay not to name the oldest. You need to use your head on this and name the person that can manage a household, has managed finances before, whether it's their own household budget and you feel like that they have done that extremely well, but also whether or not they can handle the whole process, because when administering estates, it's a time consuming process. If you think that you're not going to have to get off work one day to go to the bank or take care of some of the estate business, you're wrong. There is a little work involved. We can't do it all. The probate court really just accepts the filings and makes sure everything's correct on a regular smooth estate, and make sure that the assets are given out, distributed according to the will or according to intestate succession. And so it's a lot of the work is on the personal representative, and that's why they gave in law a fee that the personal representative is entitled to 5% of the personal property of the estate, or 5% of the net proceeds of the sale of real estate. And some folks waive that fee to give to their siblings, and some of them they earn every penny of it and some. So that's, it's a lot of work. Now that fee is also taxable. A lot of folks don't know that, but you could, it's income. And I probably have chased a rabbit, Michael, have I?
No, you haven't at all. You've hit some really good points. When I first have folks come in and sit down and talk, I try to send them the same information that I sent out to y'all in advance, because it helps them to start thinking about some of these difficult questions and explain some things that people don't know. And we talk about that holistic approach. So when I do the estate planning for clients, I don't just want to know what they want in their will. And that's important. We're going to get to that. But there's a lot of other things, as Judge Brandon mentioned, that do not have to go through probate if you properly account for it. And part of that estate in process is, a retirement account. Retirement accounts, if you have the appropriate beneficiary designations, don't have to go through probate. That's your 401k, your IRAs, your Roth IRAs, simple IRAs. And typically you can talk with your financial advisor and you can choose a primary beneficiary, which a lot of people do, right? A lot of people put their spouse down as that primary beneficiary. But most folks fail to list a contingent beneficiary. And while unlikely, there are numerous events in which both spouses unfortunately go either simultaneously or shortly after one another. And having that contingent beneficiary is really very important. And you can list numerous contingent beneficiaries. As Judge Brandon mentioned, you got 3 kids. And list all 3 as contingent beneficiaries and split it up a third each. There's no limitation on that. Same thing applies for life insurance. Life insurance proceeds do not have to go through the estate process. If you don't list the beneficiary, they will. But you can list both a primary beneficiary as well as a contingent beneficiary. I talk with clients about bank accounts as well, and whether or not those are jointly titled or if they've got any payable on death component of it with the bank accounts, and make sure that we've got that properly situated. I know some of the folks on here have young kids, and that's an important part of the estate planning process as well. While there's no requirement that the family court abide by your wishes in the will, in the event you pass and your spouse passes as well, or if you're a single mom or single dad, there's a preference that you can put in your will as to who you want the guardian to be of your children. Again, family court's not bound by that. If they look at it and they say, all right, well, Johnny's definitely not going to be in the best interest of the child because he's got all these issues, they will look hard at that because that's what you wanted. One of the other things we talk about, particularly with minor children, is a trust. And unfortunately, I think in our common parlance, everyone thinks that you've got to be a millionaire to have a trust established, and that's just simply not the case. And the reason I bring it up is Judge Brandon mentioned earlier, having a conservator appointed. In that unfortunate event where you pass and your minor children are left behind, if you don't account for where those funds are to go, there's going to need to be a conservator that's appointed for those children until the children reach the age of 18. There's an annual accounting that has to occur. It's an expensive process to go through, but that's to protect the money that you're leaving behind for your children. Instead of doing that, you can very easily, through your will, create what's called a testamentary trust. That trust does not come into effect unless you pass away. And upon passing, whatever funds that are in your estate, let's say from a life insurance policy, if you've got a $150,000 life insurance policy, instead of all those funds having to go through probate and through a conservator, you can create a trust in your will, which will allow someone that you trust to serve as that trustee, and your child or your children to be the beneficiary of that. That person's got to invest funds wisely. You can pick what age the children get the funds. Maybe an 18-year-old doesn't need to get $150,000 at once, and you can delay that date until further on, but also gives that individual some flexibility to pull out funds if the individual, if the child has some sort of health crisis or something else of the sort. One of the other things that we look at when we're doing this process too is one of the larger assets that folks have are their house. How is your house titled? Is it titled in one individual's name, or is it titled jointly, or is it titled jointly with rights of survivorship? That will impact whether or not your home goes through the probate process. And the more, not that the fees are exorbitant, but the larger your estate, the more fees that are charged against that estate as it goes through the probate process. So if you've got an expensive home, then that's going to increase the overall value of your estate. But there are ways in which we can keep that from going through the estate and give some peace of mind, depending upon, ultimately what your wishes are.
Michael, I'd like to interject here.
Please.
The fees are, what they are, and they're depending on the size of your state. The probate court fees are percentage of that, but everything that has to go through your estate is subject to creditors. That's the thing. So if there are a lot of debts in your estate, then all your assets that have to go through your estate are subject to that, meaning, you've got to take care of those creditor claims. The personal representative does, and sometimes it's possible that some of the assets have to be sold to satisfy those claims. So that's the main thing. The fees are nothing compared to the creditor's claims.
That's absolutely right. To piggyback on the personal representative and the selection of that individual, I tell clients all the time that, PR is a very thankless job. The responsibilities that are associated with it are numerous. And if you don't do it right, then that could subject that individual to some liability if they don't handle the estate affairs correctly, if they don't protect the creditor's rights, or if they dispose of some assets when they shouldn't have, or deposit funds into a different account when they shouldn't. So you have to be very, very careful when you're thinking about that personal representative. I tell folks that you want someone who's detail oriented. As you go through that probate process, there are certain deadlines. There are a lot of different requirements as to when advertisements need to be run in the newspaper and for how long, to make sure that estate is announced in a newspaper of general circulation. You got to make sure that bank accounts are open. You got to make sure that an inventory is done, an appraisal of all the property, and the personal representative is kind of charged with that responsibility. So you got to be very careful about the selection of that individual. And one of the other things, and I know, Judge Bram's got some more of these war stories than I do, but and I hope she'll share some of them with you. But I've had on two instances so far in which an individual has named a personal representative, and the personal representative never knew about it at all until the individual passed away, and we found the will, and I said, "Oh yeah, I'm in charge of this." And so the communication point that Judge Brandon mentioned was incredibly important, because that individual may not want to serve as personal representative, may not be prepared to do it, may have no clue that they are the one that is charged with that pretty awesome responsibility. So that communication component is really very important. So I think as you start to review this material and you talk with your spouse or your loved ones, it's important to go through and think about who should serve in these different roles, who should serve as a personal representative. And you can list a second and a third as folks who could serve in a capacity that in case the first person cannot serve. I do not recommend, and I think Judge Brandon would echo this, I don't recommend picking two people as a personal representative. It complicates things. There may be some disagreements amongst the personal representatives. So choose one individual, but you can choose an alternate in case the original person can't serve. Same thing for a trustee. Make sure that you find someone that you can trust, someone who's financially savvy, someone who would be responsible and want to care for the well-being of whoever the beneficiaries would be of that trust. And then, on the wills, what I also tell folks is that handles your big ticket items for the most part. It handles, where a house might go. It handles, some other real estate. It may be, once different assets are sold, this is how it's ultimately going to be divided up. But another really important part and an opportunity that you can have if you wish as you do your estate planning is you can have specific items go to certain people and attached on some of that information. I think it's the one's entitled the memorandum. On the back of it, it's just a little sheet that I have where I tell clients, look, if you got a family heirloom and you want to go to a particular person, list out that item, give a really detailed description about it, and then who you want that to go to. And you can draft your will so that all those kind of tangible personal property items that you can separate out and say, I want Timmy to get this and I want John to get that. Those will be distributed how you wish. And then anything that's left over in the estate can be sold or it can be divided up how you have in your will. So, your will kind of handles the big ticket items, but then you've got this other little memorandum that you can be attached to the will that divvies up some of those more personal property items, as family heirlooms, as things that have a little bit more sentimental value. And the last thing before I turn it back over, in that same document, again, I talked about this holistic process, and Judge Brandon touched on this. There's a lot of things that your kids may not know about you, right? And it's important that when they're handling your affairs, that they've got access to that information. And so this document, says, what your funeral arrangements are. It allows you to put down what kind of music or scripture do you want to have at that service. It allows you to indicate, where important personal documents are, passwords to different accounts, social security number. I mean, how many of you know what your parent's social security number is? It allows you to put that information down so that your personal representative will have access to that and can really, in a much more smooth fashion, kind of carry out what your wishes are. And, I've told, some of you on this, privately, that's not a comprehensive list. It's things that I've thought of, that I've come up with from talking to other attorneys, from meeting with clients. There's something else you need to add on to it, add it on there. The more information that personal representative has about you and how they can carry out your affairs, the better. And so that document isn't your will, and it's got nothing to do with the probate process or who gets distributed what. It just allows your PR to make those decisions in a much more educated fashion about what it is that you want.
All that is such good information, Michael. I mean, I really like the form that you included in the attachments, because those are things that even in myself, I forget, that I've got a savings account somewhere that I haven't really, it's just drawing interest or something. But I do like personally, when my husband went to retire from Highway Patrol a few years back, I went with him for moral support because he was scared to death that he was doing such a thing at the time. So when I was in there, they said, well, Judge Branham, let's look at your retirement information. I said, oh, no, we don't, I'm not ready for retirement. I'm just getting started. They said, no, let's make sure we got everything documented or whatever. So he pulled up my beneficiary of my retirement account, and it said estate. And I said, there is no way that this judge put estate on her as the beneficiary of her retirement. So we immediately changed it, and naturally named my husband and then my children as the contingent beneficiaries. So even though you think that everything's right, it's always good to revisit that. Check with your retirement documents. Look those up. Go to the bank and make sure that if it's possible, make sure that your spouse has access to the account if you were to pass away. There's some credit unions and financial institutions will let you put payable on death to that person. And that means that it's not going to go through your estate. If it's payable on death, it goes to the beneficiary, whoever you name the person that it's payable on death. And a lot of folks can't have a hard time understanding that. But if there's a beneficiary, if it automatically goes to someone else at the time of death, it is not a probate asset at that time, unless there's some shenanigans going around with. And that's horror stories. But for the most cases, you're not going to be able to pull that into the probate of the estate unless there was some undue influence back that they can prove. But for all you folks and on this Zoom meeting, if you have a beneficiary, it is not going to come through probate. And Michael can and look at your deeds, as Michael talked about. Things are joint, can be and with right of survivorship. And so a lot of folks really don't understand that terminology. But if it's just 50% of the property is yours and 50% is your spouse's or the other person that's on the deed, which could be a business partner or whatever. But if you actually want that piece of property to go automatically to the other person, you got to have that magic language, correct, Michael? With right of survivorship to the survivor. So you need to revisit that when you go to the law firm for your estate planning. Have a copy of all your deeds. Your automobiles can be, or if they're not, you can make them that after you get the advice of an attorney, because the attorney can say, if you're newly married and you really don't fully know that spouse, if you put Sally can go to the DMV and change the title of your BMW and skip town. So, it's one of those things you have to look at the whole picture and where you're at, and be true to yourself and be true to the attorney. So if you don't give them all the information and even what you're feeling or your fears or what your true desires, he or she cannot really advise you 100%, because you haven't given that person 100% of the information. So yeah, those things, go ahead and then if we don't do anything else, I want you to go and review all your bank accounts, your investment accounts, and your deeds to your property, and get all that information together and make sure that it's truly designated how you want it. And then I recommend every so often that you revisit your estate plan with an attorney to make sure that's really, life changes. And when it changes, it can change your estate plan, depending on if there's somebody that passed away, if you have a child that passed away or a beneficiary to your will that passed away. you might want to address it every so often. Not that you may not have to change the whole wheel. We don't really do codicils that much anymore, I don't think, Michael, because we have this computer, and you can. Used to, when I first started, when we were doing it on carbon paper, it was a codicil instead of. I'm really telling my age, and I'm really not that old, but we were doing it on carbon paper when I first started. So now we don't have so many codicils as much as we used to, but it's just easier, and it's just, I know folks don't want to spend the money, a little bit of money that it takes for the estate plan, but if you think about, or if I could give you 2 hours of horror stories, it really could save you a ton of money and a ton of heartache in the future, or your family in the future, with just revisiting that estate plan every so often. All right, where do we want to go now, Michael?
Wherever you want, Judge. Maybe a good point to stop, see if anyone's got any questions. I know we've been talking for a while, and I know that may spur some additional conversation and thoughts from you and I.
You guys, I do have a quick question. When you have a durable powers of attorney with each other, and something happens to both of you simultaneously, is there such a thing as layering those powers of attorney, or is there an expectation that you have a secondary power of attorney to the second person?
So I'll take a stab at that first. I want to make sure I understand your question, Ms. Brown. So you are each other's power of attorney, and something happens in which there's incapacity of both of you all at the time? Okay. Right. So your durable general power of attorney, and there's a new statute that was passed, I think it's 2018, which kind of came out in the new form. If you have one prior to 2018, it still works unless you want to make changes. But there's a new form for it. But it allows for you to pick a secondary, an alternate individual to serve as that durable general power of attorney. So in the event your husband is listed as your power of attorney, but he's incapacitated and cannot handle your financial affairs, there's a secondary person that you can list to serve in that capacity. And both of you all can do that.
Okay. I don't think ours were that way. Thanks, Michael.
Of course. I'm sorry, go ahead, John.
I was just going to say, I know you talked a little bit about going to individual accounts. Is there any standard way to know that like all your accounts, or do you need to go into each account to make sure that your spouse or whoever has access to those accounts if something happens? I know you said the durable power of attorney helped with that in the situation we talked about. Is that all you need, or do you also need to be named on accounts?
I think in general, it depends on what you want your overall estate planning to be. So you need to take a look at that. But in the situation that you referenced, if you have a durable general power of attorney and you allow me to serve as that power of attorney for you, Shelley, it's effectively as I'm walking into Shelley Sloan, okay? I can talk to every bank. I can talk to every financial advisor. I can file documents at the courthouse. I can sell your property. I can do everything that you would be able to do. Now, one comment about that is what I do with my clients is we'll have a durable general power of attorney executed, right? But typically what we do is we hold on to that document, or the individual holds on to that document. And only once it's recorded with the Register of Deeds does it become valid. Unfortunately, there are some folks, financial institutions, financial advisors, et cetera, who aren't familiar with that because each state is a little bit different. But if you have a signed document that's not yet been recorded, then technically it's not enforceable, but you may have some people who accept that. So again, this is where your level of trust comes into play. you're not going to list me as your power of attorney, right? You're going to list your husband as your power of attorney or another loved one as your power of attorney. And so you've got to trust that individual. But once there's an event of incapacity, then you take it down to the Register of Deeds office. It gets recorded in the Register of Deeds office. And then you utilize that document to be able to go and serve as you and to talk to all those various entities. And one final comment, because I wasn't sure if this is part of your question, was about talking to the individual banks. If you want to be able to, change your beneficiary or POD, payable on death, you've got to really piecemeal that at each different institution. And that's why we talk about, the personal representative being a thankless job, because they're going to have to handle all of those affairs kind of the back end. But what Judge Brand was talking about and just kind of doing a check every couple of years to make sure that you've got everything in line, you got to do that at each different group.
Okay. Thank you.
Hey, Mike, this is Bruce Brown. On power of attorneys, let me get it straight. Of course, I've always been under the impression, Catherine and I are both retired military. And from the first day you walk into the military, you prepare to die. Even when we deploy, we go through a line, and guess what? We see the medical guys, and they talk about medical power of attorneys and all that, and that's a big deal nowadays. And we talk to the JAG, and they talk about wills and powers of attorneys and all that, and make sure it's all done. And of course, the last person we always see in a deployment line is the chaplain. Okay. As far as power of attorneys, which the military has swayed back and forth on that because they've had some very bad experiences with powers of attorneys and limited power of attorneys and things like that. That's not true with Catherine and I. We have total power of attorneys for each other. And I've always been under the impression, I got to go back in your conversation, that you need to, upon the death of one or the other, you have to go register that power of attorney. Are you telling me you can register it in advance? Is that what I'm hearing?
So let me break it down this way, and it might help, because when Judge Brand and I were talking in preparation for this, she used this phrase, and I think it's appropriate. You kind of have two estates, right? You've got your estate while you're alive, right? And then you have your estate once you pass away. Once you pass away, Bruce, that power of attorney is no longer valid. It's gone. It's at that point, your will control, or if you don't have a will, all your affairs will pass through intestacy. Your durable general power of attorney is only valid as you are alive. It can be incapacitated, but as you are alive. And in South Carolina, your power of attorney, while it may be executed, it is not effective until it gets filed with the Register of Deeds office. It should not be, let me put it that way, it should not be accepted by a financial institution, an advisor, a courthouse, et cetera, unless it's been filed with the Register of Deeds. So if you have executed your power of attorney, given Catherine authority to handle all of your affairs, that does not become valid until she goes down to the government center and gets it filed with the Register of Deeds, and then she can handle all those affairs. But once you pass away, your life estate, and I hesitate to use that term because it's got another meaning, but your life estate ceases, and then your will, or if you don't have a will, intestacy occurs. Judge, is that accurate?
Absolutely, yeah. So I recommend that you do look at those durable power of attorneys. Now, if they're already recorded, you can revoke them and record a new one. But like Michael said, most financial institutions and folks are looking for that seal, or they should be looking for that recording. Most of them require certified copies of the durable power of attorney before they accept it. That's a good practice. If they're not doing that, they may have some issues down the road. But like Michael said, that power of attorney passes away with you. So just revisit that, look at those documents and see if you have an alternate. Because things happen and you both could be in a horrific car accident together, and you need somebody, you're going to be in rehab and unable to, take care of your daily finances or take care of the inn or whatever, and you need someone to do that, then you need an alternate on there that can take care of those things for you. Going back to the accounts and stuff, with the estate planning and the attorney that you get advice from will be able to explain that to you. But you just don't want to go and put just anybody on your accounts. I have this a lot, and I know Michael may have. They'll say, "Oh well, I'm okay. I don't need a will because my daughter's on my account," or "I don't need a power of attorney because my daughter's on my account." But there's more to just the checking account that the power of attorney helps individuals with. Like Michael said, the daughter may need to sell your house and your car so that you're able to get the kind of medical treatment at a long-term care facility that you need. But she can't do that just because she's on the checking account. She needs a document. She needs authorization. So if she's not your durable power of attorney authorized by you to do that, and then the daughter will have to petition the probate court to be appointed, and it's a process. It's litigation. It's a summons and petition, and we have to get examiners involved, and I have to appoint an attorney for the alleged incapacitated person, and then I have to appoint a guardian ad litem to go and make sure that I am appointing the right person to make these decisions for the alleged incapacitated person. And also, if that's not included, if you have your daughter needs to manage other assets other than the checking account or whatever, then she may have to be appointed conservator. And so once she's under my RAM jurisdiction, if she's appointed conservator, she has to account to me, to the court annually, letting me know how she's managing your money and your assets. And this is a lot involved in that, but it's a procedure and a process that, thank God, we have to protect individuals who can't protect themselves anymore. So there is, if you have someone that you trust, that you know will be good to handle your affairs, your property, to make decisions for you, that you have talked to and communicated what you want, then the best thing to do is to execute that durable power of attorney given that person or that alternate person. And also talk to the alternate. Let them know. So many times in the court, in this office, they'll come to the paperwork with the paperwork shaking. I had no idea I was going to be the personal representative of this estate, and that really isn't fair to your friend or your or whoever. A lot of times that happens when it's a friend is appointed or someone, and that's tough, because that is a lot of responsibility and a lot of work on that person. So that, try to communicate with them and let them know that you're thinking about, you would like to nominate them as the personal representative of your estate. And, are you okay with that? It's going to require a little bit of work, for at least a year, because the probate process, you can, at least 1 year, you can count on seeing either, hopefully not me, because that means you got some issues, but seeing one of my lovely staff members and going through that administration. But it takes a good year to probate an estate.
Quick, just to make sure, I think Bruce asked this, and I apologize if I'm asking it again, but like a husband-wife situation, if something happens to one, they have a durable power of attorney, but something happens to one, that event has to happen before you go down and register that power of attorney at the government center. Is that accurate? Or can you do it beforehand?
You can do it beforehand. It can
Okay.
be effective anytime you want. You don't have to wait for that event. Just know, and these are very limited situations. I don't want to scare anyone, but there could be a chance that Amy, right, could do something on your behalf because it's been filed that you don't want her to do. And the way the law is written, right, is it says that, even though it's filed and it's effective, it has to be, in accordance with what your wishes are, or what we presume your wishes are. And so there could be some, again, very limited situation, some litigation about that, because you may not want her to sell all those shares, and you'll have an issue. But it can be filed and effective whenever you want it to be.
Okay. All right. Thank you.
The other thing I'd like to mention too is when someone is the durable power of attorney, the attorney of fact of someone, they kind of need to know what all's involved in that. A lot of them are never explained their fiduciary duty. You can really get, it is true that they will act as as you do. They can go into the bank account and cash a check for $500 or whatever and go pick up your groceries or whatever, that kind of thing. But something that they thought they were doing innocently, they thought that they could do, could cause problems later on. So,
Right.
just, if you're the power of attorney of someone, you don't want to be regularly, and you have other siblings, you don't want to regularly cut yourself a check for running errands for your parents, whatever, because it has to be specific in that power of attorney. What that could be considered a gift if another sibling contested it. But you have a fiduciary duty, and it's way up here on acting as a prudent person would in managing those assets and those things for that person that you have been given that daunting task for. So if you are the power attorney for someone, you need to understand what you can do and what you can't do. And yeah, you can do as Michael said, but there's sometimes, if there's a sticky, tight situation and that family unit is not getting along, or they've been fighting, and that's what I see, because if they can't figure it out or they don't get along, then those are the cases that come before me. And a lot of it is sometimes the power of attorney person that had power of attorney did act out that wasn't in the best of interest of the person. Sometimes others argue that it's perceived that it wasn't in the best interest. So then that's what comes before me. But your power of attorney, that's an awesome responsibility. Just as if I had appointed you guardian or conservator, and you have to account for, and you just can't, if I appoint you, then if you're managing the funds, you can't gift yourself money. I allow a certain percentage of whatever monies you're dealing with. It's normally 2% in and 2% out to get paid back for your services of being the conservator of the person. So that is an awesome responsibility, and that's where Michael, I feel like we fail to educate the person that we're given that responsibility to. That a lot of litigation that comes before me is because they just didn't know, or they thought they had the power to do that. When they may have had the power, but it didn't pass the smell test, or it was inappropriate, and they gain. Anytime the person with the authority has a gain, it's kind of, you got to watch that. So it needs to be communicated to those folks that have that power.
Okay. I've got to drop for a meeting at work, but Shelley, Debbie, Mike, I really appreciate it. It's very helpful. So thank
you.
y'all.
Thank you for joining us.
Thank you.
Appreciate it.
There's one other thing I wanted to add. You know, we've talked a fair amount about that durable general power of attorney, and I think this is pretty clear just from the name of it. But just to spell out the differences, you know, on that healthcare power of attorney, you know, it's another document that's kind of separate and apart from what we've been talking about with the durable general power of attorney. And as its name implies, it deals with healthcare issues. And your durable general power of attorney does not control those issues, right? It's a separate and distinct document. And in that, just like you're appointing an agent to kind of handle your financial affairs, you can appoint an agent to handle some of your medical affairs. And there are different selections that you can allow that agent certain discretion. You can either tell the agent, this is exactly what I want, and I want you to tell the doctors this in this situation and this and that situation. Or you can allow your agent to make those decisions for you, you know, depending upon what health information, you know, he or she receives from the attending physician. But most importantly, it also allows them to have that communication, you know, with the doctor. You know, it happens, but, you know, South Carolina law and federal law says that, you know, I can't get medical information about my mother, right? Now, do doctors share stuff with families from time to time? Yeah, they do. But legally speaking, I can't go and talk to, you know, my mother's, you know, physician and get information about her health and well-being, even if she is in the hospital and needs, you know, emergency care. And what this document does is it allows me to have those conversations, you know, if I'm appointed as her agent. And so, you know, think about that because it's important to have as well. Again, it's a very emotional time, and you may not have had these conversations, you know, about what your kind of end of life choices are. But it's a very, if you can get over the difficult nature of the conversation, is a very easy document to execute and allows your agent to kind of carry out those affairs. That document doesn't get filed anywhere. You know, it's not a matter of public record. You know, what we typically do on those is we make sure that, you know, the agents know where those documents are. Sometimes I have my clients send it to their healthcare providers, you know, their family practitioner, to make sure that it's on file with them in their medical records so that if that conversation needs to be held, then that document is presented and allows that agent to do that.
To piggyback on that, the two main decisions that you're going to have to make is whether you're going to, and Michael's got it pointed out in his brochure, you know, leave it to the discretion of my agent. Having gone through a scenario like this personally, I just want to give you some food for thought. So you're giving the discretion to the agent. Let the agent, let my person, let my dog, whoever I appointed, let her make that decision. Or I want to withhold, or I want the Mac Daddy treatment. I don't want to go anywhere. So you do whatever you got to do to keep me alive. So number two, you have to think about on withholding or withdrawal. You don't want life sustaining treatment. That's pretty final, right, Michael? I mean, if you're saying that, the doctor's going to say, nope, we're not doing anything. But you may have done this document 4 years ago, and you know how medical science just gets better and better. So you might want to think about that. There may be a new treatment or something that could happen. You know, my brother just had COVID, and they actually gave him an experimental drug that saved his life. Had he had this, and it said no, you know, the experimental stuff or whatever. So if you leave it to the discretion of your agent, that is a lot on that agent, but that's when that communication piece comes in play. And you just need to have that hard conversation with them and include the other children if you have children or other loved ones. Because when you get in that life and death situation or that kind of decision making, it's an emotional process. You're not, you want mom or dad or you want your loved one to survive, and you don't want to make a decision that you're going to go around a year later and saying, well, what if I had just done this? What if we had just done this? So when you leave the discretion to your agent, talk to your agent about specific things. Talk. I would tell Lauren, talk to the doctor, and if if they feel and your gut is telling you that we need to see how this goes, let them know that it's okay if these things are met. Then I'm okay with no food, no water, no life-sustaining treatment. But also just talk to them and let them know that these are things that, hey, if the doctors are saying, I'm not gonna make it but 24 hours or whatever, then it's okay. I don't want to be all these things hooked up to me and all that. I don't want that. Just let me go peacefully. So have those conversations, but just know the difference. And Michael explains it to his clients. But no, if you put withhold, those doctors, it's like they love to see that because they're like, okay, we're done here. We're not doing anything. Where there may be something out new that, just like for my brother, the experimental drug, we tried it and it worked and he lived. So those are things that you need to talk about. But the communication piece with your designated agent, just have that little conversation with that person and say, this is what I want. And whatever you decide based on what I want, it's going to be okay, kind of thing.
Michael?
Yes, sir.
Michael, I have a question.
Yes, sir. Go ahead.
Yeah, Michael, this is George Foster. I have a question. Would you give a brief definition, description between a will and a trust? And the second part of the question is a will public record and a trust is not?
Sure. Thank you for the question, George. So they are, commonly speaking, there are two types of trusts. One's called a testamentary trust, and that trust is in the will itself. It's kind of part and parcel of the will, and it becomes effective once you pass away. And if there are certain assets that you want to go into that trust, then that trust is formed upon your death. I gave the example earlier of creating a trust in your will for the benefit of say, some minor children, or if you want funds reserved in a trust for the benefit of some charitable organization, you can do that as well. That's a testamentary trust. Only becomes effective upon your death. The second kind of more common form of trust, not more common, but another form of trust that folks commonly use is an inter vivos trust, and that is during the life of you trust. You can create it today if you wanted to, George, and that trust document becomes effective whenever you sign it as the settlor, and you appoint who you want to serve as that trustee, and it's funded. And there are two forms of an inter vivos trust. One is called a revocable trust. That means you can revoke it at any particular point in time. And the second is an irrevocable trust, meaning once you establish it, it's set unless there's certain circumstances that maybe go beyond where we are today. And so those are your forms of trust documents. Judge, I'm going to let you speak to the public nature of the will. I'll just make one comment. Right now, George, if you draft and execute a will, that is not a public document. But eventually, once you pass away, it does get presented to probate court, and I'm going to let Judge Branham touch on that.
So once an estate is open or a will is probated, because that's two different things also, the will, once it's filed with the probate court, it is public record. And the estate is public record except for the death certificate is not public record because it falls under HIPAA. It's considered a medical document. And so it's not public record. And then I require a copy of a picture, a government photo ID of the applicant applying as personal representative, so that if that person ever walks into the office, I can identify them as to who they are. And that is not public record. And so, yeah, the estates, or if anyone wants to come and look in an estate, if they have an interest, or they're doing genealogy, which we don't have that much of that going on right now because of COVID and the fact that the courthouse is pretty much closed to the public only by appointment in my office right now. But yes, the estates and wills are public record. But trust or not, if I have trust litigation, like Michael said, if there's trust litigation, and that happens some, it's not public record. It's kept away from the public.
Thank you.
Yes, sir.
Jill asked a question earlier privately in a chat. She was just throwing some things out there. She has 2 children in college. So they would be considered adult children. Should they consider some kind of power of attorney for them since they are not minors anymore? I know they probably don't have a lot that they own, but should there be some kind of power of attorney situation that you consider for your adult children?
It's a good question. It really is. And it's something that is popping up a lot more all over the country, not just in South Carolina. And it's quite candidly kind of a contested issue, and in the sense that there are very divergent opinions on the best approach. Like much of this estate planning, I think it goes back to your individual family circumstances. It's really important. I keep talking about holistic, and I'm sorry, but you have to look at the entire picture of things, and what may work for my adult children may not work for yours. And you may have some moms when you've got a 20-year-old kid who's in the hospital and wanting to have conversations with the doctor and making sure that that child is cared for, and that is completely understandable. Doctors shouldn't have those conversations, but you can understand why a mom or a dad would want to be able to have those conversations on a kind of the healthcare power of attorney side. Same thing on the durable general power of attorney side. We talked a little bit about litigation, with respect to some individuals maybe going outside of the scope of what their authority is. And so it really is fact dependent, and it would be hard for a one size fit all approach. And I would want to sit down the individual and flesh out those questions and want to know why that they think that is important. And to be very clear, just because mom wants Timmy's durable power of attorney and to be able to serve in that capacity, it's got to be Timmy that gives it. It's got to be his sole decision to do that. And folks do a number of different approaches on this. Whenever I do my will execution, whenever I do my power of attorney execution, everything else, whoever a beneficiary is underneath that will, whoever a personal representative would be underneath that will, they are nowhere near my office because I want to be 100% certain that there's zero undue influence on the part of any outside actor that may suggest that this is what mom wants or this is what dad wants. And we all, as attorneys, when we draft those wills, we have to be very cognizant of that. We got to make sure that person is of sound mind and is competent, and everyone has a different approach to it. There's a series of questions that I kind of ask and go over, particularly if it's someone that I don't already have a working relationship with. And you got to make sure there's no undue influence. There's a lot of litigation about that. And one of the ways I make sure I do it is that I don't even want that person driving them to my office, right? I want who may be a beneficiary underneath the will or a PR underneath the will. And so we try to make sure that all that is done above board, even with those power of attorneys, because it keeps it, or shall I say, it's less likely that it would end up on Judge Branham's desk because you put some of those different measures in place.
A little bit further into that question, just kind of trying to figure things out. I've got a freshman in college and a sophomore in college, and both of them were working a little more independence. One would rather me still go to every single doctor's appointment with him. My daughter's getting a little bit more independent. She is at the University of Alabama. And so my thought on that would be, let's say, she, got in a car accident or something like that. So as far as like phone calls and everything, because I would believe that they're not supposed to just talk to me if I ask. But that was just something that, with today's technology, it came up on like a Facebook parents board and different opinions on that. So as far as our family getting access, would that be something that just in general is smart to do if both parties think that, like my children would want me to know? So I'm just asking, is that something that would be smart for us to pursue as a family?
So in that situation, I don't think it would be a durable general power of attorney that you would need.
Right, exactly.
That healthcare one. And in that particular situation, assuming your children want that to occur, then it may be smart to list you as an agent so that you can continue to have those conversations. I would encourage, both parties, just like Judge Brandon was mentioning earlier about a periodic review of this,
Definitely.
that it's something that you guys look at on an annual basis to make sure it's still making sense, and that your child knows that it's something that can be revoked really at any particular point in time if he or she wants that to happen.
Definitely. Thank you.
Mm-hmm.
Well, that just made me think of something that I need to take care of personally, because we have a son that has type 1 diabetes, and knowing what I know in the court when he turned 18 and was in college, I said, oh my gosh, I need power of attorney of him, but something happened. So we did that route. It was so I have power of attorney for him, but now he's married and he needs to revoke that power of attorney. So that's on my list. Look at there. Y'all triggered something for me. I hope that this has been helpful and not overwhelming for everyone. It's so hard. My workshops are 3 hours, 2.5 to 3 hours long, because I actually go through the whole process. And we also integrate some of these questions. We do talk about estate planning, and I have an attorney there to advise. And I hope to be able to start those back. It may be in the form of Zoom meetings also, but it's a lot of material to cover. I think my desire, as I said before, if I can get you all to revisit what you got, your estate plan you already have, or even start an estate plan, at least, think about getting that durable power of attorney taken care of and a catch-all will. And then, in that, going through that estate planning process with an attorney. I don't recommend trying to do that on your own and Googling it and loading down documents off of the internet, because it normally ends up to be a hot mess in my office or in my court when those are happening. Just an example, I had a will this morning that one of the girls brought to me and said, "Judge, read this will." They went through all this long wording that they probably had no clue what they were typing. And they appointed someone, but they never told me what they wanted to do with their stuff. So guess what happens? It becomes, the division of it goes through intestate statute. So, I can appoint someone to handle all that, the person that they wanted to, but they didn't tell me what to do with it. So those are the kinds of things that, need to be done properly. And I don't work on my car for a reason, because I'm not a mechanic. So I wouldn't, you don't need to be practicing law or trying to do your own estate plan without some good legal advice that knows the laws of South Carolina and knows the whole, can look at the whole picture for you and give you a good advice as to what to do.
And thank y'all so much. I think the big takeaway for me is communication. It's the hard conversations to have, but I have aging parents that I need to have those conversations with. I need to have those conversations with my husband. So I know what I've got on my docket in the next couple of weeks to sit down and have those. Stop putting them off.
Right.
Actually, I think it's been very helpful. Ironically, when you brought up the oldest child and everything, my parents have been very detailed in theirs. I am the oldest child, but theirs was more, they're afraid if one of my sisters just pushes, I'll just be like, okay, take whatever. So I've been following up things on that side, but I haven't thought about the other side as far as like my husband and me and going backwards with the children. I'm so focused on, well, my parents are older, so the expectation is that would happen sooner. So I've just taken a lot of notes to go both directions to make sure that everything's updated. So this has been very helpful.
Well, thank you to Graham Realty for sponsoring it and Shelley for organizing this. We really appreciate it.
Oh, well, it was easy with you two taking the reins and making this happen with all this wonderful information. We appreciate you both.